Chapter 16 of the Kenyan Constitution outlines the procedures and requirements for amending the Constitution. The chapter specifies two ways in which the Constitution can be amended: through a parliamentary initiative, Article 256, or through a popular initiative, Article 257. Additionally, it identifies certain matters that require approval through a referendum, and it establishes the conditions for successful amendment. 255. Amendment through referendum. Article 255. Proposed amendments that relate to specific critical matters must be approved through a referendum. These matters include the supremacy of the Constitution, the territory of Kenya, sovereignty of the people, national values and principles of governance, the Bill of Rights, the term of office of the President, the independence of the judiciary, commissions and independent offices, functions of Parliament, devolved government, and provisions of Chapter 16 itself. To be approved, a referendum must meet two conditions. At least 20% of registered voters in at least half of the counties must participate, and a simple majority of the citizens voting in the referendum must support the amendment. 256. Amendment by Parliamentary Initiative. Article 256. A bill to amend the Constitution can be introduced in either House of Parliament. The bill cannot address any other matter apart from consequential amendments to legislation arising from it. It must pass both Houses of Parliament in its second and third readings with at least a two-thirds majority of all members in each House. If the bill proposes an amendment related to matters specified in Article 255 Clause 1, a referendum is required. The President must request the Independent Electoral and Boundaries Commission to conduct a national referendum, and the bill must be approved in the referendum before the President can assent to it. 257. Amendment by Popular Initiative. Article 257. An amendment to the Constitution can also be proposed through a popular initiative signed by at least 1 million registered voters. The popular initiative can be in the form of a general suggestion or a formulated draft bill. If the initiative is in the form of a general suggestion, the promoters must formulate it into a draft bill. The Independent Electoral and Boundaries Commission verifies the initiative's supporting signatures to ensure it meets the required number of 1 million registered voters. The draft bill is then submitted to each county assembly for consideration, and if approved by a majority of county assemblies, it is introduced in Parliament. If Parliament passes the bill, it is submitted to the President for assent. If Parliament fails to pass the bill or the bill relates to matters specified in Article 255 Clause 1, it is subjected to a referendum. The referendum process follows the conditions set in Article 255 Clause 2.